Hi, this is Jennifer Witt with the Witt Law Group. I'm here to address some issues or concerns people often have in that initial step of should I hire a private defense versus a public defender. And that is totally understandable. Private defense is expensive, and for a lot of families, they don't have that kind of money just laying around, so they really want to justify that decision, and I don't blame you. And it's hard to really get facts on that, because if you call any private defense firm, sometimes you get really the hard sell, the fear, all of those type of things. So hopefully this 3 or 4 part series Ryan and I are putting together will kind of just give you some facts. They may or may not be, apply to you. You may decide, hey, I'm fine with a public defender, and that's okay. But it's important to educate yourself as to certain things that are happening in a case and why it may benefit you to have private defense over a public defender. Number one is the myth that you'll qualify for a public defender. Many people assume that you automatically will. And it's interesting because within the state, each county has different qualifications. So perhaps you did have a criminal charge 2 years ago, you qualified for a public defender in Seattle. They have different standards of indigency, or essentially think of poverty. Can you actually pay for your adequate defense? In Kitsap County, the qualifications for indigency are different. So, or essentially the qualifications to get assigned a public defender may be different depending on whether you're charged with a felony, a misdemeanor, a juvenile offense, things of that nature. And you can find that on the Kitsap Public Defense site. However, during that time when you're waiting and you're deciding, you are missing really critical things, critical steps you could take. And what I'm about to say may surprise a lot of people because, I'm talking about DUIs, assaults, things of that nature, but I actually am a huge advocate of keeping you driving. And people will think that is crazy because, gee, why would you advocate for a person who was under the influence behind the wheel? And the reason is the vast, vast majority of our clients and majority of DUI defendants, it's a one-time mistake, a terrible mistake, and the vast majority are ashamed and embarrassed and would never do that again. But the issue is, if you wallow in that kind of embarrassment or self-loathing, you're not making progress. And that is the point in district court, is to essentially learn your lesson, never make that mistake again. And it's less of a punishment model, let's say. It's a therapeutic model. And part of that is maintaining stability. I want you to have a license. I don't want you to go to your arraignment and have to get an ignition interlock license when you really don't need one. You've never had a history of a problem, and now that may pile on thousands of dollars for you. You can't make your house payment, or you just simply can't put the ignition interlock in, and therefore now you're violating your conditions. You can't get to work, or you can't maintain stable family life. And so that's a real problem, because let's say you do need assistance, like you need treatment, you do have an issue with addiction, and maybe it's a mental health issue for you right now. In that case, you are not going to, statistically, you're not going to maintain that. You're not going to reach out. You're not going to complete the treatment, or you're not even going to sign up when your life is in chaos, when you have financial instability. And that's really important where private defense comes in, because you don't get a public defender until arraignment. It's not actually your public defender. They're stepping in for you to help you plead not guilty. They are not dealing with conditions of release in terms of really individualized arguments, right? They just will meet you. And so that's a big factor, where if we even have hours, sorry, my screen got funny there, but if we even have hours to manage this, to get you looking better in front of the court, it's possible you may have little to no conditions of release. You may not even have to go to your arraignment. Maybe we can waive that arraignment and keep you financially stable. So that's one of the biggest things that is not a factor for public defense. It's not their job to do that. It's not what public defense dollars are meant for. It is to simply deal with the facts of a criminal case. But as you probably are finding out now, if you're looking at these videos, a criminal charge encompasses a lot more than just that issue. It's so many tangential factors in your life. It's going to affect your employment, your security clearance, perhaps you're in a family law, having a family law issue, a divorce, a custody battle. It's going to affect that. It's so many things that you need counsel on. So that is probably the long-winded answer to there are so many things you don't know, but don't make the assumption you qualify for public defense, because you lose valuable days and weeks and months where a private attorney would be on the case immediately, reducing the consequences that would impact all of those other side issues, particularly stability, which is what we really want for our clients. We want to make sure you stay employed. And I'll give you one example. Sometimes it comes up in the most random ways, but last week Ryan was able to reduce or eliminate somebody's restitution. It was over $4,000. That $4,000 was more than what the individual paid us for our legal fees. So it's not a guarantee that that's how it always works out, but there are so many ways in which it becomes a cost benefit to you to have private defense, and make sure you maintain that license, maintain that job, get rid of any expenses or costs, fees, financial obligations, things of that nature that don't need to be assigned to your case or we can argue to have removed. So hopefully that gives you a few facts to chew on and continue on to the rest of our series. Thanks.